SJC-11864, Gregory T. Magazu, et al., the Department of Children and Families.
Good morning, Your Honors.
Wait 1 second, Mr. Bonanza. Good morning now.
Good morning, and may it please the Court. I represent, of course, the Magazus, who appealed their denial of a foster parent license by DCF. The sole reason for their denial is religious belief and practice, albeit admittedly proper, albeit admittedly increasingly infrequent, spanking their own two daughters, then 9 and 7, if other lesser measures were not effectual. There is no dispute that the Magazus are great parents and qualified in every way. There is no dispute that they agreed not to spank the foster child. There is no dispute that the first two levels of DCF representatives would have granted them this license.
Now, they applied not only to be foster parents, right? They applied also to be adoptive parents.
Yes.
So they were reviewed as adoptive parents as well as foster parents, and they did not agree that if they were able to adopt these children, that the children would not be subject to corporal punishment.
DCF never broached that issue with the appellants, but they did mention kind of on both sides of it that in one side of the issue, when they became adoptive parents, they were free to parent as any parent would be free to parent. Then they also said in the administrative record that they could impose conditions in that adoption agreement relative to how they would parent that foster parent who then becomes adopted.
Well, with respect to what Justice Ling said, I thought the record does, indicate somewhere that they did not commit not to using corporal punishment if and when they adopted a child.
I don't think that issue was ever broached. It was never broached. They didn't go there, but the DCF was on both sides of the issue, saying, well, we have no further jurisdiction once you become a parent, but then we ask the question, well, in the process of the adoption, you enter into agreements with adoptive parents. Yes, we do. And can they have conditions? Yes, they can. Could one of them be this condition? Yes. So we never got there. And then the other issue is...
So you're saying that it could be a legitimate condition?
I believe so, Your Honor.
How could it be enforced?
I don't know, but...
Could it be a criteria for whether or not you can be an adoptive parent? In assessing suitability of adoptive people who apply to be adoptive parents. If they say, well, we would include among the kinds of discipline measured corporal punishment when we think appropriate, just as we do with our biological children. Would it be appropriate for the DCF to say, no, given our population of children, who are so many of them afflicted with a history of abuse, we would not regard you as suitable to adopt if you plan to use corporal punishment, even if, sparingly.
Well, I think that that practically is the case. That with regard to the foster care contract, which of course is temporary parenting under the auspices of DCF, the regulations do provide that they require the foster parents to submit in writing an agreement saying you will not spank the foster child.
So the question is, can you do a similar thing for the adoption?
I think you can, because there's no compulsion for DCF to sponsor a petition to court for that adoption to occur. There can be conditions.
Mm-hmm. Okay. So the problem here is that it's not so much that the DCF, you're saying, couldn't condition the ability to become a foster parent or an adoptive parent on an agreement not to spank these children from DCF.
That's right.
But that you can't make it a condition that they can't spank their own children,
Right.
their own present children.
That's right. And that is the issue. The regulations only speak to the foster child. The regulations do not speak to one's own biological children. That one has a right to parent their own children as they see fit, provided they do not abuse or neglect those children. And that right, of course, is of constitutional magnitude.
Do you say that DCF's concern that a foster child placed in this home, although the child may not directly see a sibling or a foster sibling being corporally disciplined, would nevertheless learn about it and either be further traumatized beyond what trauma the child may have had in the home from which the child was removed, or feel that the child was being disparately treated in terms of the dispensation of love and affection? That's not a legitimate concern by DCF?
Well, the first issue is this. Here we are in the context of the State Administrative Procedure Act, and as the court has ruled in Cobble versus Commissioner, the expertise of DCF is not substantial evidence. There must be expert testimony. The testimony at the fair hearing here was that this is subjective, not objective. This is, quote, a best guess, end quote. And there was no expert testimony to indicate that if a child saw or if a child heard, a foster child heard, that a biological child had been spanked, that they would re-experience trauma.
So DCF's policy, and I take it that they have a policy of not placing children in homes where there is corporal punishment, is essentially an illegal policy because it's unsupported.
Let me tell you also another reason why, Your Honor, because this policy is not in the regulations, it's not written, it is a, quote, long-standing policy and practice, end quote, in the Western region, not even statewide. And yet, this policy somehow should override the statewide regulations.
Well, the statewide regulations don't address it at all, right?
Well, we say they do because the regulations say you cannot spank the foster child and you must agree to that in writing. Now, if the legislature in the rulemaking authority, the legislature said in Chapter 119, Section 37, that DCF must administer its duties in accordance with its regulations. And its regulations have been promulgated, and they speak to the issue of spanking, but they only speak to it relative to the foster parent. If they wanted to speak to it relative to the biological parent, they would have.
But its regulations also state that a foster or pre-adoptive parent applicant must demonstrate to the satisfaction of the department the ability to promote the physical, mental, and emotional well-being of a child placed in his or her care. And if the department is of the view that the spanking of another child, which would likely become known to the foster child, would be a source of trauma to that child who's already likely suffered some physical abuse or neglect, is that an unreasonable position to take?
It is for two reasons. One, going back to Cobble versus Commissioner, and the cases cited in that, for this proposition, there is no substantial evidence in the record that they, A, complied with the regulations, and B, had evidence that that was the case, that A, that was reasonably likely that this foster child would see and hear of spanking, and that this foster child would re-experience trauma. There's no expert testimony.
But why do they
at the
need
fa-
expert testimony? They've been charged with the enforcement of the statute. They've been charged with the custody of these children and to look out for their well-being. And there is a certain amount of expertise that they do have in carrying out the functions of the statute, the purposes of the statute. And one of those purposes is to place them in a home where they will not be further traumatized.
Your Honor, in response to that question, I asked the decision maker at DCF at the fair hearing myself, if these potential foster parents agreed not to spank their own children, would they be approved? Answer, no. And that is Appendix 146.
But you haven't answered my question.
Well, relative to the spanking issue, it's been decided by the promulgation of regulations that specify one thing but don't specify another. So they want to drive a truck through suitability and say that ipso facto, virtually anything could be.
But my question is, are you disputing the expertise that the department has with respect to the function that has been entrusted upon them, or entrusted to them by the legislature, to look out and carry out regulatory measures and concerns for the best interests of these children who have already been traumatized, likelihood of trauma, and the placement of them in homes where that trauma will not persist or will not be continued. And I hear you saying that they don't have expertise in order to make that determination. And it's my understanding, at least I think our case law says, that agencies do have a certain level of expertise for the purpose of carrying out the functions of the legislature, that the legislature has placed upon them.
Let me give you an answer to that question as carefully as I can. There is a principle in appellate review, of course, of deference to the agency because of its expertise, but that deference, it's been said very often, is not abdication. Secondly, this expertise occurs within a regulatory framework. Now, I am not saying that DCF doesn't have expertise. I am saying that they have to act and they have to exercise that expertise within the regulatory framework. They cannot do it by fiat. And the hearing officer found this, and I thought this was very curious, that it is the worldview of the appellants, the worldview that collides with the policies and practices, not regulations, of DCF. They're incompatible, indeed prohibitive to placement. That sounds a lot like religious belief. That sounds a lot like their religion. The Hebrew and Christian scriptures tell us, whoever spares the rod hates his son, but whoever loves him is diligent to discipline him, from the Proverbs. DCF is saying that Christians and Jews need not apply to become foster parents or pre-adoptive parents if they practice the scriptures.
Well, are you suggesting that, put aside your arguments about whether there's expertise, about whether it's appropriate to not have, for foster children to be able to witness or live in a house where corporal punishment might occur as a potential for re-traumatizing. Are you suggesting that if somebody has that, adopts that tenet as a religious belief, the state cannot say you can't, under any circumstances, because it would be a violation of their free exercise of religion, can't say you can't be an adoptive parent or a foster parent?
I'm saying that that's what they're saying. I'm not saying that. Indeed, the regulations don't say that. The Constitution doesn't say that. But that is what they're saying. They're saying your worldview collides with ours.
But at some point, if your worldview, however based on religious practice, may be determined by the DCF to be a source of trauma or abuse to a child, may they not protect a child from that?
If that is in the regulatory framework, there are, of course, procedures post foster care placement, post adoption even. 51As and 51Bs, a whole procedure for that issue, should that become an abuse or neglect situation.
Well, there is what about the regulation 110 Code of Mass Regs, Section 7.104, small 1, or 1 in parenthesis, to promote the physical, mental, and emotional well-being of a child placed in his or her care. Are you saying that regulation isn't consistent with the department's view or DCF's view in this case?
Well,
Or that they
I'm
weren't
saying-
acting pursuant to that regulation?
that's a broad regulation, but there are more specific ones that speak to the very issue, and that excludes what it doesn't say. If they meant to say, well, look it, we want parents, because that's an issue, because there's so many abused children, we want it to be that, look, there's no spanking anywhere in this. Then the regulations would address it. They don't. They don't. They only talk to the foster child.
So I'm a little bit confused as to what your position is. If there were a regulation that said that there shall be a written agreement that a foster parent shall not use corporal punishment against the foster child or any other member of the household, would that be okay?
If the rulemaking process was proper, I would say yes.
So regardless of your religious objection, you would say they can do that. So this is purely an issue as to whether or not they've complied with their own regulations, not a religious issue.
Well, I think it's both.
Well, now I'm confused because you just said that they could do that, even though you now claim that there's a religious objection to doing that.
Well, what I'm saying in the rulemaking process, if there's going to be what's called, to get over the burden of unconstitutional conditions, which is, Dolan versus City of Tigard, a U.S. Supreme Court case, and many other cases, they have to demonstrate. If they're going to say to you, look, you can be a foster parent. That's not a right. That's a privilege or a benefit, whatever you want to call it. But you're going to have to shed some of your constitutional rights at the door. You're going to have to say, okay, you can't parent your children in just the same way you want. That is, you're going to have to not spank them. If they demonstrate in the rulemaking process that there's a reasonable relation to those two things, then the rule may be promulgated in a way that is correct and I believe would uphold constitutional scrutiny.
Okay, thank you.
I see my time is up. Thank you.
Good morning, Your Honors. Assistant Attorney General Annapurna Balakrishna on behalf of the Department of Children and Families. Your Honors, children in the department's custody have seen and witnessed terrible things. All of them.
Let me ask you this. Do you have a long-standing articulated policy that parents who spank their own children cannot be foster parents?
The evidence in this record shows that the Western Area Office of the Department for at least 16 years had never placed a child in a home in which the parents used physical discipline on any child.
But not having done so, did they articulate that as a policy?
They said that that was the practice of that office, and in the fair hearing decision, they said that as well.
So if the family moved to Boston, it would be okay?
No, Your Honor, it's just not in this record.
So when we're talking about, just to be very clear, I know this is what we're talking about, but I just want to make sure. We're talking about corporal punishment that is not excessive, that falls within the parameters of, as we've defined, it's only used to correct, and then it can't rise to a level where it's in any way harmful. So it's SWAT on the behind type of corporal punishment, I'm taking it, right? Because otherwise, of course, then you'd be engaged in harm. Are you suggesting that this is appropriate as a carte blanche? There are kinds of rules that no matter how or what the child who's being placed, that you don't have to show there would be potential harm from that kind of behavior, notwithstanding a loving environment else in every other respect? That it's, and because it's a privilege, that's the rule. So yes, I take it, first of all.
Well, the department's position
I just never
is-
heard of this before, so I'm interested in the policy
Of
and
course.
how it's administered.
Of course, Your Honor, and the
Blanket
department's...
rule.
The department's position here is that the law of the Commonwealth has recognized that corporal punishment or physical discipline is completely appropriate if properly administered. But the department's position, in this case and in general, is that when it comes to foster children, it's not... There are so many unknowns as to what that child has experienced that it's not appropriate in a home in which you're putting a foster child, because the department does not always know what that child has seen or experienced, and does not know always if that child will be able to distinguish between lovingly administered physical discipline and abuse. The record has some evidence on this issue, including the training that the department asks foster parents to undergo before finishing the application. And I think it's on the record at page 83. They do have that training manual, and they do discuss why physical discipline in the home is problematic for foster children. Some children who have been abused before entering foster care are used to pain and have to be hit harder, and then they see it as a way to get attention from the foster parent, just as the way they got it from the biological parent. And therefore, they will work harder to try and get that same kind of attention from that foster parent. That's what our record shows us. We also have testimony from the social workers that in their experience, shepherding families and children through this process for many years, that it is just not compatible. They don't know what the children have experienced. The children can't always tell them, and the children sometimes don't remember.
But this is not a regulation. You're saying this is just a policy and practice of a particular office of DCF?
The regulation, Your Honor, says that the foster family must be able to satisfy to the department's satisfaction.
The department's satisfaction.
The department's satisfaction that they were able to provide for the emotional, mental, and physical well-being of any child placed in their care. So that regulation is the one that was relied on by the fair hearing officer and the department in the final decision here.
In using Justice Botsford's, or picking up on Justice Botsford's hypothetical, what if a family has a foster child and the family employs corporal punishment with respect to other children, and they live in the Boston area and then move out to the Western region? The case is transferred to the office in the Western region. What is the response of the office in the Western region to that family?
Well, it's my understanding that the department in general probably wouldn't approve them. That's not in our record. This was a 38 case.
They would take the foster child out of that family?
No, I think the department's position, as it's been communicated to me, is that family wouldn't have been approved.
It
Well,
wouldn't be a
but-
family in Boston. in other
The family in Boston probably wouldn't have been approved because it's somewhat of an understanding in...
So it's really a statewide departmental policy that hasn't...
It's not written anywhere, Your Honor, and it's not in our record, but it's my understanding that that's the department's policy.
Is the policy the same for non-familial placements or only, and for family placements? You engage in the same kind of questioning about past discipline or proposed practice of discipline?
I don't know, Your Honor. I think that when it comes to family, depending on what kind of family it is, for example, if it's a sister or something, the sister cannot adopt. So I think the analysis might be different. If it's for an aunt or uncle, maybe they would be analyzed as adoptive parents. I don't know. I would assume that if you have, the reasoning would be the same, that if you have had a child that's experienced some kind of abuse, either witnessing it or experiencing it firsthand, that you don't want to put that child in a home where those triggers are going to be. And I think the evidence shows through the training manuals that that is somewhat of a widespread belief in this field.
And because you can never know for sure with a particular child, then you apply it to all of the children who are part of the DCF.
Yes, Your Honor, and it's interesting, the evidence does show through the social worker's testimony that when children, it's not, the children don't always just land and stay in the same place. Sometimes the child is placed and then goes back home and might experience abuse there and then come back to the foster family. So it's a fluid process. The department doesn't always know what the child has experienced when it first goes to a home. It might go back home and there might be a problem and then it comes back. The department, when approving foster placements, they're just trying to do the best they can to make sure that the family home would be safe for any child.
I understand
And
that.
that's it, isn't it? I mean, isn't what's getting approved is the family as a foster family? It's not that the family is going to be an appropriate foster family for this particular child. That's a later decision.
Right, Your Honor, and I think that's why we can distinguish this from Cobble, because that was a particular kid, and you had to have evidence that supported that the action in that case would harm that particular child. In this case, we're talking about the hypothetical child, any child. So the considerations are different, and I think it's fair to say that the department, especially the social workers in this case, who had been with the department for 16 years and seen many, many families, I think it was appropriate for her to testify and that for her testimony to be credited, that it's contradicted.
Ask you a question about the record.
Yes.
Mr. Bondanza said it never came up about whether if his clients were to become adoptive parents, because it was a foster adoptive, that it never came up whether they would agree or did agree that they would not use corporal punishment on their adopted child. But I'm seeing in Judge Davis's opinion on page 11 a sentence about the decision reflects evidence that any child the plaintiffs ultimately might adopt likely would be subjected to potentially traumatic episodes of corporal punishment in a very direct way. So my question is, was that an issue or wasn't it?
Well, the social workers did testify, and the hearing officer, I think at fact finding 12 and 13 in their decision, did credit that testimony that the social worker, based on the assessment of the family, believed that post-adoption corporal punishment probably would be used. And that was something that the fair hearing officers saw the woman testify. They also saw the petitioners testify. So those are credibility determinations. I don't think it would really matter in this case if a written agreement said that they wouldn't physically discipline the potential adoptive child, because they were clear that they did not want to refrain, or they couldn't because of their beliefs, refrain from physically disciplining their own children. And that is one of the major problems, because the idea that one child will be treated differently than another child in this particular way is problematic. And that the petitioners said that the potential foster children would not see or hear anything about the corporal punishment was also problematic, because number one, the department hopes that the child will be integrated in the family and there'll be open communications and no secrets, and it's not clear how the petitioners would be able to keep the other children from talking to the potential foster child. So it just raises a whole host of issues, and they have never stated that they were willing to sign an agreement saying that they wouldn't physically discipline any of their children.
Do you agree, though, that the ability to serve as a foster or an adoptive parent is an important benefit, and that the department's practice here in some fashion burdens that religious exercise?
No, Your Honor. I don't believe the case law supports a conclusion that the ability to serve as a foster parent is an important government benefit. In a sense, it's not like unemployment benefits, and the First Amendment case law seems to characterize the issue not as to say something is a benefit or not, but whether the state action is coercing or compelling the person who feels their rights are being violated from doing something contrary to their religious beliefs. So
Said in Curtis that a violation of the right to free exercise of religion may occur where the state conditions receipt of an important benefit on conduct proscribed by a religious faith.
yes,
So is this an important benefit is the question.
I don't think so, no.
You think the ability to serve as a foster or adoptive parent is not a benefit?
No, I don't think it's a benefit, Your Honor. It is an opportunity, a chance, and more importantly, it is not the only way that somebody can be a foster parent or an adoptive parent. The evidence in this record does show that there are other agencies that do allow people to foster children. There could be adoption through a mother, and I think the evidence through the testimony said that a mother or a family with a child that they want to have adopted can have a private agreement, and the department's decision here will not be discussed with those people unless the petitioners release it. So the department's decision here is not preventing the petitioners from becoming foster or adoptive parents. It just,
This route, this particular
this
way.
particular route, Your Honor.
Is it your view that the department would have the power to say that a certain religious group may not be foster parents because that religious group holds to a tenet which DCF considers to be harmful to a child?
I think the answer to that would be if it is based solely on a religious belief, the answer would be no, that would be impermissible. But if it's based on conduct that could harm a child, it would be a fact-specific inquiry depending on the conduct and the child at issue, the type of child at issue.
Fact specific to each applicant?
Depending on the situation, I would think in this particular, you'd have to think about the hypothetical Department of Children, the hypothetical foster child, what characteristics that they do have. For example,
All have the same characteristics of prior trauma necessarily?
yes, but certain conduct might not harm them. It just depends on what that conduct is. And in this case, it is conduct that has been determined through clinical observation to not be compatible with their needs, the hypothetical DCF foster child.
Hypothetical, previously traumatized who might be re-traumatized child.
That hypothetical child. We're talking about hypotheticals in this particular
They all
situation. Well, they're all traumatized in different ways, yes,
traumatized?
in different ways.
I gather the concern was that you can't tell.
That is one of the main concerns, is that some of them are nonverbal, some of them have repressed what has happened to them, and sometimes you don't know what's happened to them until after they've been placed. It takes years of therapy before they're able to talk about it. So it depends on the child and
Have
its...
infant placements?
Well, there are infant placements. An infant, even a newborn who's separated from their mother or father, is going to have needs that are different than the infant that is not. But the department can't guarantee an infant. And
Could preclude all but infants who were taken from
Right, but-
mothers who have been ingesting cocaine, and therefore their children were taken it.
correct, Your Honor, but in many of those cases, the minute the child is born, he's not, in some of them they are, but in most of the cases, the child goes back and forth for a bit, and the mother or the father tries to work with the department to try to get the child back. There might be periods of time the child is with the foster parent. There may be a period of time the child is with the biological parent. We won't know what happens to that child once he's or she is there. So the department really doesn't want these children to be moving around all the time. They want them to have that one family, form that bond to that family. And this is one way that, as a practical way, the way to achieve that mission.
All right, thank you.
Thank you, Your Honors.
SJC-11846 in the matter of Chandrakant Sridhar Panse.